Good morning. We're going to do some jury charge again. I'm going to do it just a little bit slower for some of the slower speeds. This is a criminal case. And let's see how we do. Take a deep breath. Ready? Ladies and gentlemen of the jury, after the attorneys have presented their summations, you will go to the jury room. You will then select one of your members as your presiding juror. It shall be your presiding juror's duty to preside over your discussions of and deliberations upon the case, vote with you, and when you have unanimously agreed upon a verdict, by signing the same as your presiding juror. You will have this charge with you in the jury room and shall refer to it for guidance during your deliberations. Suitable forms for your verdict are attached hereto. Your verdict must be in writing and signed by your presiding juror. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this case, and restrict your deliberations solely to the issue of whether the defendant is guilty or not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court as it is given to you in this charge, and you are bound to be governed thereby. You shall consider only the evidence and exhibits presented here in the courtroom through the witnesses who have testified. If you want to have the exhibits with you in the jury room for your deliberations, advise the bailiff. In deliberating on this case, you shall not talk to anyone except the members of the jury about it until you have been finally discharged from service on this jury. If you want to communicate with the court, explain what you want in writing and deliver your message, signed by your presiding juror, to the bailiff, who will deliver it to the court. Do not orally explain to the bailiff what you want. You are instructed that the grand jury indictment is not evidence of guilt. It is a means whereby the defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing up on the innocence or guilt of the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense does not give rise to any inference of guilt at the trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. The court has admitted into evidence before you the alleged video recorded statement of the defendant, and you are instructed that before you may consider the same for any purpose, you must first believe from the evidence beyond a reasonable doubt that the same was freely and voluntarily made by the defendant without compulsion or persuasion, and that prior thereto the defendant had been warned by the person to whom the statement was made that 1. He had the right to remain silent and not make any statement at all, and that any statement he made may be used against him at trial, and 2. Any statement he made may be used as evidence against him in court, and 3. He had the right to have a lawyer present to advise him prior to and during any questioning, and 4. If he was unable to employ a lawyer, he had the right to have a lawyer appointed to advise him prior to and during any questioning, and 5. He had the right to terminate the interview at any time, and that the defendant prior to and during the making of the statement knowingly, intelligently, and voluntarily waived these rights. But if you do not so believe, or if you have a reasonable doubt thereof, then the alleged statement is entirely withdrawn from your consideration, and you shall not give the same any force or effect whatsoever, or consider it as any evidence of the defendant's guilt in this case, and you shall not consider any evidence obtained as a result thereof, if any. Our law provides that a defendant may testify on his own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations, or take into consideration for any purpose whatsoever as a circumstance against him. A person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. A person is nevertheless criminally responsible for causing a result if the only difference between what actually occurred and what he desired, contemplated, or risked is that 1. A different offense was committed, or 2. A different person or property was injured, harmed, or otherwise affected. You are instructed that if you find that there is evidence of an injury to Joe Brown having occurred prior to the injury in question in this case, you are not to concern yourself with who might have caused any prior injury to Joe Brown. Bold-face lettering of words or phrases in this charge indicate that such words or phrases are defined in this charge and nothing else. Words not defined herein have their ordinary meanings. Definitions. A person commits injury to a child if the person intentionally or knowingly, by act or omission, causes serious bodily injury to a child then and there younger than 15 years of age. You are instructed that a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. You are instructed that a person acts knowingly or with knowledge with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Child means a person younger than 15 years of age or younger. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes the death, serious, permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Act means a bodily movement, whether voluntary or involuntary. Omission means failure to act. The defendant, Mark Smith, stands charged by indictment with injury to a child alleged to have occurred on or about the 25th day of March 2009. To these charges, the defendant has pleaded not guilty. Now, if you find from the evidence beyond a reasonable doubt that on or about the 25th day of March 2009 in El Paso County, Texas, the defendant, Mark Smith, did then and there intentionally or knowingly by act cause serious bodily injury to Joe Smith, a child younger than 15 years of age, by then and there striking Joe Smith about the head with an unknown object, or did then and there intentionally or knowingly by act cause serious bodily injury to Joe Smith, a child younger than 15 years of age by then and there striking Joe Smith's head against an unknown object, or did then and there, intentionally or knowingly by act, cause serious bodily injury to Joe Smith, a child younger than 15 years of age, by then and there shaking Joe Smith, a child younger than 15 years of age, by then and there shaking Joe Smith's body. You will find the defendant, Mark Smith, guilty as charged in the indictment, unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant, Mark Smith, of injury to a child as charged in the indictment. Manner of deliberations. A. In order to return a verdict, each juror must agree thereto. B. Jurors have a duty to consult with one another to deliberate with a view of reaching an agreement, if it can be done, without abrogating individual judgment. C. Each juror must decide the case for themselves, but only after an impartial consideration of the evidence with their fellow jurors. D. In the course of deliberations, a juror should not hesitate to re-examine their own views and change their opinion if convinced it is erroneous. E. No juror should surrender their honest conviction as to the weight or effect of the evidence only because of the opinion of fellow jurors, or for the mere purpose of returning a verdict. F. In arriving at your verdict, it will not be proper to fix the same by lot, chance, or any other method than by full, fair, and free exercise of the opinion of the individual jurors under evidence admitted before you. G. Do not let bias, prejudice, or sympathy play any part in your deliberations. The presiding juror or any other juror who observes a violation of the court's instructions shall immediately warn the one who is violating the same and caution the juror not to do so again. After you have arrived at your verdict, you will notify the bailiff that you have reached your verdict. That is a standard jury charge in a criminal case that I have done. That's actually one I have done here in court. I changed the names, but that kind of gives you an idea of a jury charge in a criminal case, injury to a child. Hope you enjoyed it, and let me know what you think.